Okay, Facebook likes to screw up my videos at this point, but we are going to do a nice little video for you Indiana folks out there, and we're going to show you how to find their bonds in the state of Indiana, their surety bonds. Okay, so right now I am dealing with Grant County. And let's see, Grant, nothing else. We're gonna look for their bonds here. Hopefully all right. Oh, nice. What's the deal with that? Come on now. Drop this down. There we go. Now you're cooking with Crisco. All right, so today, I was denied entry into the courtroom. I was also denied my cell phone. That's standard protocol here with criminals in the 21st century who are laundering money, abducting children, involved in kidnapping, extortion, executive order violation 13903, 13818, United States Code 227101, and Indiana Code Section 3542, 3.5 and 1.4. And they're abducting children, and they're selling them for profit and gain, unjust enrichment. So, after a couple of people sent me this sweet young lady's information about collecting and collapsing their surety bonds, I started to delve in and do a little due diligence, okay? Because what these people are engaged in is nefarious activities to unjustly enrich themselves, all at the peril of American men and women. They are warring against the people of the United States of America, okay? They've pretty much run out of people to go to war with, so now they're just warring against everybody, and they always have been, because war is very profitable. Now, I want you to focus right here. We're going to notice, I can't zoom in on this, this is Grant County, County Clerk, individual bond, okay? And per, let me find it here, got it in my paperwork, do all this research, and the judge just says, denied. Well, I'm glad you said denied, because that means that you actually took the time to fucking read it. Otherwise, you wouldn't be able to deny it, right? You'd say, I need some time to read this, and I'll give you my evaluation after I've read the document. But no, she didn't say that today. She just flat out said the documentation is denied, all right? So she's on the hook here because number 8, Dana Kenworthy, doing business as Honorable Judge Kenworthy on behalf of the state of Indiana per IC Indiana Code 54118, local officers, employees, and contractors, surety bonds, and criminal policies, amount, form, term, requirements, Section 18A, except as otherwise provided in subsection B, C, and D, the following individuals shall file and maintain in place an individual surety bond during each year that the individual serves as an officer, employee, or contractor. 1. City judges, controllers, clerks, and clerk treasurers. 2. Town judges and clerk treasurers. Public officials' surety bonds request fall under the Freedom of Information Act, FOIA, F-O-I-A, 5 USC, subsection 552, the Sunshine Act, Title 5 USC, subsection 552B, Indiana Access to Public Records Act, subsection 51431 ETSEQ, and by law, you are obligated to supply Gregory Lee Wilder with this information within 7 business days. Now, that's because it's in writing. When you do it in person, they have 24 hours to provide that for you. Now, I have looked for Dana Kenworthy's surety bond. And so when we type in, let's just say we're going to type in judge, okay? And we hit enter. And it refreshes. And right at the top of the screen here, let me scroll up so you can see it. Right at the top of the screen here, we've got one judge. But the problem is this is for Grant County, but it's for the city of Gas City, and this is Baker Stevens. His surety bond is at $15,000. Let's just see what a surety bond looks like, ladies and gentlemen, and where, in fact, the insurance corporation, the surety, is located. So Stephen J. Baker, or Barker, excuse me, which is not our principal that we're going after at this point. First of all, I want to point out that Stephen J. Baker is a false and fictitious assumed business name. It may be registered, it may not be at this point. We haven't done our due diligence because this isn't the guy that we are focusing on. This is a clear and cut violation of the Real ID Act. Per Federal Rules of Civil Procedure, Rule 11B, and the Real ID Act, actors, agents, and assigns working on behalf of the foreign principal corporations are, in fact, non-compliant per the record of this court, whereas every agent and agency is utilizing a false and fictitious unregistered doing business as name, assumed business name, in clear violation of Federal Rules of Civil Procedure, Rule 11B, and Title 6 CFR 73.3, full legal name, violative appellation, as well as proper name pursuant to Title 18 USC 1342. Okay, so this name right here is a false and fictitious misnomer. Okay, it's an unregistered DBA as far as I know at this point. Now, the onus of probandi falls back on me because I'm making the statement that this is an unregistered doing business as name or assumed business name. And simply to prove my point, I would simply get a hold of the Secretary of State for the state of Indiana, and I would inquire as to whether or not Stephen J. Barker, as it is right here, is in fact a registered assumed business name, trade name, or doing business as name. Now, the Secretary of State will promptly report back to me either affirming or denying that Stephen J. Barker is a registered assumed business name. When that comes back, this is identifiable through the Secretary of State as a false and fictitious business name as principal, and the Ohio Casualty Insurance Company as surety. They're the surety, okay? They are the ones that you're going to bring your claim to when Stephen J. Barker violates his oath of office, engaged in mixed war against the Constitution, violating your unalienable rights, so on and so forth. Now, however, they're required to carry a bond per the Indiana code. And if they don't have this bond, their office is vacant. And they're actually supposed to have this bond prior to taking their oath of office. It's a requirement that they have a bond in place prior to taking the oath of office, or they are not seated in office, okay? As surety, as well as all heirs, executors, and administrators of the principal and surety are bound jointly and severally to the state of Indiana in the amount of $15,000. Now, what this means is if your claim surpasses $15,000, now we need Stephen J. Barker's 433A and 433B. Because although he's compliant with his surety bond here, the problem is if you make a claim for, let's say, $100,000, the insurance company known as the Ohio Casualty Insurance Company may state, "Hey, we'll cut you the check for the 15 grand or whatever." Now, this is probably 10% of what the actual bond is. Remember when you go to jail and they're asking for 10% of $50,000, so you're going to pay $5,000. I'm presuming and assuming at this point that this 15 grand is actually for $150,000 insurance policy. Now, if your claim goes over that, then what you're going to need from Stephen J. Barker is, in fact, a 433A and a 433B filled out, and you're going to compel him to do that through the court to fill out a list of his business assets and his personal assets to ensure that when you liquidate his estate, you can be made whole for the full sum. Okay. If subpart B is violated in all other respects, the following conditions apply to the public official bond. The principal is duly elected, commissioned, appointed, and employed as a city court judge, City of Gas City, for, this is left blank, in the state of Indiana. The principal shall faithfully perform and fulfill his or her duties of the position named in subparagraph A, including compliance with IC 511 and paying over on demand to the person entitled or authorized to receive the same, all monies that may come into his or her hands during the term of his public official bond. The term of this public official bond is for 1 year term, being on the first day of January 2021 and ending on the 31st day of December. Now, as I'm going to point out to you here, if you go back here in Indiana, they're always quick to give you the year prior, but you will notice that 2022 is not an option here, okay? But the good news is, let me click off on this and do this. The good news is here, we are now seeing a pattern in Indiana of who the insurance company is. So now I want to go to Grant County. We had an issue where we were denied due process of law, whereas Pamela Harris failed to give us a docket number so we could state our claim for which relief could be granted. And her bond is set at $300,000. Now, I'm guessing again, if it's a $300,000 bond, I'm guessing that's 10%, and it's really a $3 million bond. I could be egregiously incorrect in my assessment, but I will do my due diligence, as always, to find out the truth. However, this bond expires as of December 21st, the 31st day, 2021. And as you can see, we do not see an option for being able to view Pamela Harris's bond for 2022. Okay, so we're going to have to do some due diligence. But when we go back here, and again, we look at who the bonding agent is, okay? We're going to go ahead and I agree with the governor. The governor is the chief magistrate of the state, okay? He's basically the president of the state. Every state is a corporation, a subsidiary corporation of the United States, Title 15, 3002-15A. So we go back here, and it's really interesting how the judges are only bonded for $15,000, whereas the clerk of the court, who really pulls all the strings, is bonded for $300,000, okay? Now, something that we're going to see here that is similar is the fact that Pamela Harris, okay, it appears to be her full name. Perhaps she doesn't have a middle name, so we can't make the assessment that she's doing business under a false and fictitious misnomer, all right? But we will see here that the Ohio Casualty Insurance Company, who I will be contacting directly for what transpired today, is in fact as surety, okay? So we're going to get a hold of this agency, and we're going to let them know that their agents, after 7 business days, are non-compliant with the Indiana Code for providing their surety bond information, so we can collapse that motherfucker for mixed war against the Constitution, not only for the state of Indiana, but also the United States Constitution, okay? And under 63 Charlie and jurisprudence 2D, ladies and gentlemen, all public officials are, in fact, trustees of the American people. I don't care how you slice it, how you dice it, I don't give a shit what late night infomercial you watch. It is a fact, okay? So we're going to move forward with this because denial of due process of law, mixed war against the Constitution, treason, extortion, human trafficking, the trafficking of children, unjust enrichment, allowing false and fictitious statements and false and fictitious plaintiffs to be utilized in an egregious attempt to extort the American people is in fact a violation of their oath of office. Now, somewhere in here, there is an oath. Ha! There it is. Let's check it out a little bit, shall we? Okay, first of all, we're going to notice that it doesn't appear that any of this has been notarized. All right? State of is blank. County of is blank. I mean, for an official record, this sure looks pretty fucking shoddy to me. I, Pamela Harris, do solemnly swear or affirm that I will support, protect, defend the Constitution of the United States and the Constitution of the state of Indiana. Now, you're never going to believe this shit. In Nebraska, I've had clerks of the court tell me, we don't uphold the Constitution, Derek. We don't enforce the Constitution. We don't use the Constitution in our courts. Well, guess what? Thank you for your fucking admission and violating your oath of office. Thank you very much, because I record every phone call that I ever make, and every incoming call that is ever made to me is recorded just for these fucking purposes. And that I will discharge the duties of my office of Grant County Clerky I don't know if that's a typo or if it's supposed to say clergy or clerky. If it's a typo, again, there's some pretty shoddy fucking work here. Anyway, for people that are supposed to be pay acute attention to detail, clerky seems pretty quirky to me. With fidelity, that I have not paid or contributed or promised to pay or contribute, either directly or indirectly, any money or other valuable things to procure my nomination or election or appointment, except for necessary and proper expenses expressly authorized by law, which they don't state the law, so it's vague and ambiguous, that I have not knowingly violated any election law of this state or produced or procured it to be done by others in my behalf, that I will not knowingly receive, directly or indirectly, any money or other valuable things for the performance or non-performance of any act of duty pertaining to my office than the compensation allowed by law. So help me God. Now, what's funny is they tell you there's a separation between church and state. Well, here's a statement right here that blows that shit right out of the fucking water, okay? So help me God. That's her oath of office, okay? So that would be the Title 5 3331 oath of office to do business and commerce, because the actual Article 6 oath does not say, so help me God, okay? Because religion was never part of governing the American people as far as holding office. It is not a requirement, period, okay? So, on this, we also see that there's a power of attorney limits the acts of those named herein, and they have no authority to bind the company except in the manner and to the extent herein stated. The Ohio Casualty Insurance Company power of attorney. So this is the Ohio Insurance Casualty Company actually holds power of attorney of this $300,000 bond, and they are authorized to pay out as surety to any man or woman making a valid claim. Now, the Ohio Casualty Insurance Company is responsible for conducting a sua sponte investigation into the subject matter of whether or not Pamela Harris did in fact knowingly, intelligently, and willingly violate her oath of office, which would be a breach of the trust, causing harm, damage, and loss to I or somebody else, to kickstart this $300,000 check coming across the board. Now, again, if you're bringing a claim for, let's say, well, this is $300,000. This may be 10%, ladies and gentlemen. Remember, when we're bonding something, typically the rule of thumb is it's 10%. So this could be 10%. 10%, I believe it would be something like, what would that be, $30 million or $3 million? Anyway, you guys do the math. I'm not a mathematician. I need a calculator, and I haven't had sleep in 48 hours because I've been working on this case that was, of course, it's denied. Oh, really? On what merits? Finding of facts and conclusions of law. You sit there on that bench all high and mighty and toity-toity, and yet you're not willing to listen to anything, let alone the agricultural lien that supersedes your UCC1s or any presumed and assumed authority that you may have. That agricultural lien supersedes everything you guys are doing, and it gives rise to us bringing a claim for a substantial sum of currency, which we really don't give a shit about. We want this young man brought home, all right? Because he's better off in his family's household. Not only is the family being caused harm, the offspring is being caused harm. He's being denied the right and opportunity to bond with his familia. And at the end of the day, the only thing that really matters in this world is your bond with God, your faith, your religion, your spirituality, and your bond with your family, okay? That's what really matters, because when shit hits the fan, family is literally all you have. Like them, love them, hate them, don't, whatever. The case is substantial in the essence that family really is what we have. Know all men by these presents that the Ohio Casualty Insurance Company, a corporation duly organized under the laws of the state of New Hampshire. Okay, so this is interesting. They're authorized under the state of New Hampshire here. This is an insurance company, but their primary location appears to be the state of New Hampshire, herein collectively called the company, pursuant to and by authority herein set forth, does hereby name, constitute, and appoint Timothy A. Milkowski. Forgive me for the name if it's incorrect and you're watching this, brother. I did not mean to slaughter that. It's pretty unique. Maybe it's Jujewski, Maloki Jaguski. I'm gonna stop because I'm just slaughtering it. Anyway, in the city and the state of Seattle, Washington, each individually, if there be more than one named, is true and lawful attorney in fact to make, execute, seal, acknowledge, and deliver for and on behalf as surety and its act and deed any and all undertaking, bonds, recognizance, and other surety obligations in pursuant of these presents, and shall be as binding upon the companies as if they have been duly signed by the president and attested by the secretary of the company in their own proper person. So this man right here seems to be the guy that we would be getting a hold of for old Panny. All right, Timothy A. Miklajoskowi. I'll ask him his name when we contact him, because you can bet your sweet ass I'm calling. All right. Signed by the president. Okay, we already went through that. In witness whereof, this power of attorney has been subscribed by an authorized officer of the official of the company, and the corporate seal of the company has been affixed thereto this 26th day of September 2016. Okay, this is clear back in 2016. I'm not sure what their requirements are as far as power of attorney, if they're just standing and continually running until altered, or what the deal is, but we will get to the bottom of it, because David M. Carey, Assistant Secretary for the Ohio Casualty Company, is who we're going to be contacting, all right? And we're going to be in hopes to be speaking with Timothy A. I'm not even going to try it. I'm just slaughtering it. Again, so let's see what else. State of Pennsylvania, County of Montgomery, SS. On this 26th day of September 2016, before me personally appeared David M. Carey, who acknowledges himself to be the Assistant Secretary of the Ohio Casualty Insurance Company, and that he, as such, being authorized so to do, execute the foregoing instruments for the purposes therein contained, by signing on behalf of the corporation by himself as duly authorized officer. Remember when we talk about UCC 3-402B, when we're talking about authorized representative, if they're signing as authorized representative, don't you think you should be doing so, or doing the same? All right. In witness whereof, I have hereunto subscribed my name and affixed my notary seal at King of Persia, Pennsylvania. It is Prussia, Pennsylvania, on the day and year above written. Above written, where the hell is that? Okay, so 26th day of September 2016. Okay, and we've got a notary seal here. All right, we're good there. Let's see what else this little ditty is going to provide us. And again, this is for Indiana. I come across a gal a while back who's talking about collapsing surety bonds. I really like her style, and it avoids a bunch of lawsuits, which could be timely. They could take years, months, days, weeks out of your life. Who's got time to do that shit when you can just simply collapse their surety bond, remove them from office, and they'll never hurt another American man or woman again, because they will never be able to be bonded again, all right? This power of attorney is made and executed and pursuant to by the authority of the following bylaws authorized of the Ohio Casualty Insurance Company, which is now in full force and effect, reading as follows. Article 4, Officers, Section 12, Power of Attorney. Any officer or other official of the corporation authorized for that purpose in writing by the chairman or the president, and subject to such limitations as the chairman or the president may prescribe, shall appoint such attorneys in fact. Okay, so we're talking about attorneys in fact. We're talking about presidents. We understand that this is a corporate charter. Okay, well, what we're delving through is their corporate charter bylaws. This could even be perceived to be as a trust indenture, if you will, as may be necessary to act on behalf of the corporation to make, but it's obviously a corporate bylaws and charter. Execute, seals, acknowledge, and deliver as surety any and all undertaking, bonds, recognitions, and other surety obligations. Such attorney, in fact, subject to the limitations set forth in their respective powers of attorney, shall have full power to bind the corporation by their signature, and executed such instruments shall be as binding as if signed by the president and attested to by the secretary. Any power or authority granted to any respective representative or attorney in fact, under the provisions of this article, may be revoked at any time by the board, the chairman, the president, or by the officer or officers granting such power or authority. Certificate of designation. The president of the company acting pursuant to the bylaws of the company. There we go. Now we know what we're dealing with. We're dealing with the bylaws of the company. It's a corporation. It's an insurance policy, okay? It's a bond. They're the surety. She's the principal. You're the claimant. Authorizing David M. Carey, Assistant Secretary, to appoint such attorney in fact, as may be necessary to act on behalf of the company to make, execute, seal, acknowledge, and deliver as surety any and all undertaking, bonds, recognitions, and other surety obligations. Authorization by unanimous consent of the company's board of directors. The company consents that facsimile or mechanically reproduce signatures or electronic signatures of any assistant secretary of the company, or facsimile or mechanically reproduced or electronic seal of the company wherever appearing upon a certified copy of any power of attorney or bond issued by the company in connection with surety bonds shall be valid. Ladies and gentlemen, they're giving you the bylaws. They're telling you how they're operating. They're telling you that if they do an electronic signature and it's a certified copy, it is as good as the original, ladies and gentlemen, and is valid and binding upon the company with the same force and effect as though manually affixed, okay? So we're getting their bylaws, we're seeing how they operate, we're understanding that if they send us the check, the surety bond, and everything in tote, and it's certified, and it's got the signets and seals and everything like that, and it's all digital or electronical, that it is still valid, okay, per their authorization, okay? I, Renee C. Lewin, the undersigned Assistant Secretary of the Ohio Casualty Insurance Company, do hereby certify that this power of attorney executed by said company is in full force and effect and has not been revoked. In testimony whereof I have hereunto set my hand and affixed the seal of said company this 10th day of November 2020. Okay, so now I need to get a hold of this Ohio insurance company and make sure that appears to be out of Pennsylvania and ensure that they are still up to date and current with this record, because we have a claim, not a complaint, a claim that is going to be made against Pam Harris and her conduct that has caused us harm, damage, and loss by violating her oath of office, breach of trust, ladies and gentlemen. There is no higher offense than breach of trust. It doesn't get any greater than that. A breach of trust is devastating. I mean, this is when you start talking about treason, mixed war against the Constitution, denial of due process of law, all of these things. Let me reiterate this. Without due process of law, ladies and gentlemen, there is no law, period. Due process of law is quintessential in all aspects of life. Without it, there is no law. All right? Contract creates the law, equity follows the law. That maximum is limited, but it applies here. Okay? Equity imputes an intention to fulfill an obligation, ladies and gentlemen. They took a fucking oath, bind their asses to it, accept it, acknowledge it, demand their surety, show where your authority comes from as far as the code for the state that requires them to be independently bonded prior to taking oath of office. Okay, and if they weren't independently bonded before they took the oath of office, ladies and gentlemen, the office is vacant. Okay, and here again we see that this pertains to the Indiana Code, because the public official bond complies with IC 54118, all right, which is what I read to you guys earlier under Section 8 of the document that I slaved over for the last 48 hours to create. And that is as follows. Dana Kenworthy doing business as Honorable Judge Kenworthy on behalf of the state of Indiana per IC 54118, local officer, employee, and contractor surety bond and crime policies, amount, form, term, requirements, Section 18A, except as provided in subsection B, C, and D. The following individuals shall file and maintain in place an individual surety bond during each year that the individual serves as an officer, employee, or contractor. Contractor, ladies and gentlemen. Where do you have contractors? You have contractors in commerce doing business. Where do you have employees? You have employees doing business, ladies and gentlemen. Okay, and officers of what? Title 28, 300215A, and their subsidiary corporations, as defined by the federal government. City judges, controllers, clerks, and clerk treasurers. 2. Town judges and clerk treasurers. Public officials, surety bond request fall under Freedom of Information Act, FOIA, 5 USC subsection 552, and the Sunshine Act, Title 5 USC subsection 552B. Ladies and gentlemen, the last two that I just read to you apply nationwide. Okay, in all 50 states, Title 5 USC subsection 552 and Title 5 USC subsection 552B apply in all states, okay? And then it's also reaffirmed in the state's code. Indiana state's code, for example, is IC 51431 and IC 54118, all right? And by law, they are required, if you're doing it in written form, according to the IC code, the Indiana code, to provide that information within 7 business days. Failure to do so would be another breach of trust, okay? So when I call these people, I'm going to ask if this is 10%, if the $300,000 is actual 10% of the original bond. How much is the original bond worth? Because this appears to be 10% of what that bond would be worth. All right. Let's see. Oh, and that brings me to my next point. The alleged judge that we were dealing with in Grant County today, who absconded from allowing me in the courtroom, even though I have interest in said matter and a right to be heard, is not on here. Okay? There is Grant, Town of Fairmont, Grant County. There are no Grant County judges listed here. There's the sheriff, the coroner. The sheriff carries a $90,000 bond. The coroner carries a $90,000 bond. It's important to know that the coroner is the only one that can arrest the sheriff, just so you're all firmly aware of that. So if you're having problems with the sheriff and you're giving them notice and an opportunity to do a sua sponte investigation and apprehend public officials who are fucking criminals, ladies and gentlemen, and he won't do his job and do an investigation, a sheriff's inquiry is what they're called. He won't hold his own court and call together a grand jury and have them review evidence to find out whether or not it constitutes crime, then you can get a hold of the coroner, tell the coroner where the sheriff screwed the pooch, and have the coroner arrest the sheriff. Okay? Now, if you talk to the coroners, a lot of coroners will go, I hope it never comes to that, because they know that when they have to arrest the sheriff, shit's about to hit the fan in your community. All right? So that's important information to know as well. But as we go through the Grant County, township or county in and of itself, I see nowhere where there's a Grant County judge. So we go up a little higher and hold on. City of Marion judge. We have a Hotz Michael $15,000 bond, which seems pretty skimpy for all the fuckery that they're involved in and stealing offspring and human trafficking and everything else. You would think their bond would be closer to what the comptroller and the clerk of the court is, which is $300,000. Let's look at City of Marion. There's only one judge, City of Marion, one judge on file that was compliant as of 1/1/2021 to 12/31/2021. I see no evidence on this record anyway that they are compliant as of to date. We have another judge that's on here, but it's for a different location, the city of Gas City. And again, I don't see Dana Kenworthy on here from 2021. And we know damn good and well that she was involved in a multitude of court cases in 2021. But if she wasn't in